Welcome to the Frazier and Deeter Culture of Compliance podcast. The first in our series is addressing GDPR and what organizations need to know. My name is Sabrina Serafin. I am the Process Risk and Governance Practice Leader here at the firm. And I'd like to introduce our guest. We're happy to have with us today Ian Singer, a partner in Frazier and Deeter's UK sister firm, PKF Littlejohn. Ian is the leader of PKF Littlejohn's IT practice group, and he's the firm's leading expert in GDPR. We're also joined today by Gina, a partner in Frazier and Deeter's technology practice. Gina is one of the lead partners at Frazier and Deeter for data privacy compliance, including GDPR. GDPR is a topic with ongoing debate on how to comply and wide variance of understanding of the law and how it will be operationalized. Let's start by defining GDPR. Ian, for our audience, could you provide us with an overview of the changes that GDPR is introducing to the environment?
Yes, thank you, Sabrina. So GDPR is a new law coming into effect on 25th of May 2018. It will replace all existing data protection laws across the European Union. Here in the UK, it will replace Data Protection Act, that's been around for almost 20 years, supplemented by e-privacy laws which govern email communications and the like. So this new law is going to be the first time that the whole of Europe has the same data privacy requirements, and it raises the bar compared to the current legislation as to what is required to be compliant. Now, one of the key things with the new legislation are the penalties that the regulators can apply in the event of a breach. So under the new law, they can fine an organisation up to 20 million euros or 4% of their global turnover, whichever is the higher number. But that is a massive increase on the current regimes across Europe. And although no one's expecting the regulator to levy the highest fine immediately, nonetheless, the scale of fines available to them to apply is obviously that much higher. And it could be significantly damaging to anyone falling foul of the regulatory breach. The new law is based on the current legislations, but it is a different law. It increases the requirements, it raises the threshold of what compliance looks like. And in particular, there's some interesting additional requirements around data subjects and their rights. But there are a number of very specific additional requirements that GDPR is asking people to deliver over and above the current data protection legislation in Europe. The first one is you have to demonstrate a data governance framework that ensures you're doing the right thing and not just relying on normal behavior or past experience. The second thing is you need a dedicated data protection officer if you are handling sensitive information. The third, and one of the big ones I think, is what we call privacy by design. What that means is every decision you take that regards IT or data, you've got to ensure that right at the heart of your decision making, right at the heart of your system design, is keeping information secure and confidential. Following on from data governance requirement is a key requirement that you train your staff on a regular, appropriate basis. So you keep them up to date with what's happening, the behaviors you expect of them, and they know what to do in the event of a breach occurring. There's also some differences around what people can ask you to do on their behalf, and we've touched on this. This is subject access requests, where you have to deliver up to your individuals the information you hold about them. They have the right to be forgotten. They can say, please don't have my information on your systems anymore. And they can also say to you, and a regulator can say to you, please confirm to me where you've got the consent for holding this information and using this information. And I think that's a key point there. There is a difference between, do you have the right to hold it, and do you have the right to use it in the way you want to use it? So somebody might well be a student of yours or a client of yours, and that's why you have the information. That doesn't give you free range to market them any product at any time you like. And the final one is you've got to be able to demonstrate the legal ground for processing your information that you're holding. So you can't just assume it's okay to have it. There are 6 legal reasons to hold information and use it. The 3 main that will probably apply to most people are consent, which we understand. Someone says you can have it and can use it. It's performing a contract or delivering a service. You are an accountant for them, for example. And lastly, what's called legitimate interests, which is quite a high hurdle to overcome. But there will be situations where getting consent is not appropriate or it's impossible, but there's still clearly a reason why you need to engage with that person. And in particular, that's to do with what information do you hold about them and can they get access to that. The right for someone to say, please forget me in your systems in my entirety. So don't have any record of my presence in your systems anywhere. These are quite different to the current law and will be very hard for some firms to comply with. The other thing to understand is that for the first time, this law applies worldwide if you are dealing with EU citizens' data. Now that's quite a change. Whether they can enforce it in the States, for example, will be interesting, but it has the force of law at face value, which is why American institutions do need to comply. And one of the things I think people need to be aware of overseas is that even if you think you may not be fined by the regulators over here, what you will find, and it's already happening, is your counterparties in the EU will be asking you for evidence of your compliance under GDPR. And if they're not convinced you have appropriate safeguards in place, they will have to stop dealing with you. So I think the fines, although they are hitting the headlines because they're quite big numbers, are not the real risk. The real risk, I think, to organisations is counterparties stopping working with you.
Ian, I want to just touch on a couple of those and dive a little further. I think some of them, such as training your staff by providing security training and access requests, may be commonly implemented within organizations. So hopefully they're already doing that, and hopefully they can already prove how they are performing those procedures and provide documentation of that proof. But I will say that privacy by design and a little further of where you're holding this data and what you're doing with the data, I could see those areas as being a little more complicated and difficult for organizations to actually prove. And they're really going to have to start thinking about what they're doing with data and how privacy is really a part of their organization. Another challenge for organizations is the right to be forgotten, and that organizations may not realize all the places that people's data may reside, and how old that data is and what they're doing with that data. So organizations certainly need to start looking at the data they have received from users maybe years ago and figuring out what to do with that data and what they are using that data for.
Excellent point, Gina. There's API that will provide redaction of personal information. There are opportunities for data mapping that could identify all possible areas that data would be maintained. These are exercises that organizations may have to perform. And Ian, perhaps we should ask, what was the impetus for GDPR? We could go back that far. Why the change?
Yes, I think there are a number of reasons. Firstly, most data protection laws are, as I say, getting up to 20 years old. And clearly the world has changed radically in that time, particularly with digital marketing, digital devices, the amount of data that we all generate and use. And it was also an attempt to have a single regulation across the European Union, rather than differing standards, which was causing issues, particularly with companies that trade cross-border. So it was really an attempt to modernize data protection laws. But interestingly, at the core of GDPR are 8 data protection principles that have been there for 20 years. So in fact, the reasons that people want to keep data secure haven't changed for a very long time. What has changed are the risks the number of places your data may be held and used, and the number of times you want to let people use that data. It's a much more complicated, much more risky environment we live in, and the law has been changed to reflect that.
So as technology has changed, as must the laws to protect individuals.
Exactly.
You brought up an excellent point, Ian, and one that I'd like to turn to Gina to address. And how might organizations evidence that compliance that they're required to have in place for their counterparts?
Right. So I think the first step for organizations that are dealing with GDPR and are wondering how they can comply with GDPR is to perform a risk assessment around the personal EU data that they are retaining and collecting. And this begins with understanding how they are capturing this data and where they are storing that data, as well as who has access to this data, including any third parties that would be significant to the organization. Another key step within this process is for organizations to define a data protection officer. This person is the one-stop shop for data protection. They are an expert who has knowledge of data protection laws and practices. And another key piece with this data protection is also expanding breach notification procedures within an organization.
Thank you, Gina. Ian, you addressed the fact that there's a lack of recognized standards. So there's been many debates around this, and for organizations that are going through the procedures and processes that Gina referred to, what is the guiding light? Where should they be looking for that overall guidance?
Yes, that's a very good question, and it's a hot topic over here at the moment because the GDPR law is less than 6 months away, and to a large extent people are having to interpret the law without very much to guide them. Now, the regulators across Europe, in particular in the UK, the Information Commissioner, are starting to release some guidance, which is helpful or not, depending on your particular circumstance. But most of the really key guidance people are waiting for is not going to come out until sometime in the new year. And it's probably going to be too late to understand what they are suggesting and respond. So in our view, you're going to have to make the best stab you can at what you think compliance looks like. But this is a regulation, it has a regulator, and our experience with regulators generally is they want to see you have a process you are following that's not luck, it's not a mission, you are taking a serious view of what's required of you, have a process in place with good internal conversations, with the right people, like the data protection officer that Gina referred to, being part of that conversation. And at the heart of those conversations, you put the rights of the individual, not your rights, not your requirements, not what suits you, but what's right for the individual whose data you are holding. And in fact, GDPR actually is quite a simple law in some ways. What it's really saying is the individuals concerned, they have the right to say who has their information. And they have a further right to say how those people use their information. It's not more complicated than that, actually. It's who has it and how they use it. Now, in order to demonstrate compliance, whatever that means, because the law and only the law, test cases ultimately can really confirm what the law means or is meant to mean. In the interim, you do the best you can by ensuring you've gone through proper processes with a proper governance framework around data protection, and you make good decisions that reflect the need to look after the individual's information. If you can show that, then the chances are you're probably okay. But there is currently nothing that says I'm a standard you can get certified against, and if you have that certification, then you are compliant. That isn't going to happen, I think, certainly before May and probably not even after May, because it's the law, and laws don't generally have standards you can comply with. It's a law. Only time will tell what the regulators believe is compliance.
That's a great point, Ian, of discussing how companies are showing improving compliance. And what we've begun to see happen in the U.S. is companies are starting to incorporate the GDPR framework into their existing compliance procedures. One example of that is into their system and organization control reports, also known as SOC reports. We have assisted companies by mapping their current SOC controls and procedures against the GDPR framework. And our goal is to test once and report many on these different frameworks and how data is being protected.
Since we're on the topic of attestation reporting, and we are talking about the culture of compliance, Ian, can you speak to how organizations can actually leverage what they are doing to comply with GDPR in whatever way, shape, or form they are doing, but how they can leverage that to actually raise their profile in the marketplace?
Well, absolutely, and I think it is a genuine point that obviously non-compliance is very, very bad for business. But equally, being able to demonstrate a good regime where you can gain the trust of your intended client market is hugely beneficial. People spend millions and millions of dollars trying to raise their brand and get people to trust in their brand. Well, this is a very good way of being able to demonstrate you are trustworthy. And particularly if you are an arm's length supplier, which I guess some of the companies in the States will be with their EU client base, it's going to be doubly important you have a way of demonstrating you are treating their information with respect, that you are a company that takes data governance very seriously, and you can prove that fact. You should find people are much more willing to come to you than perhaps your competitors who perhaps can't demonstrate that. It's exactly the same reason why people go to Amazon rather than other websites. They trust Amazon. It's all about trust.
So understanding there is a competitive advantage, there also may be marketing procedures that could lead to, again, raising the profile of an organization that have evaluated GDPR risk controls and implemented controls to mitigate that risk. However, since there is legal implications with organizations that violate GDPR, is there a risk to marketing themselves as compliant, and I'm using air quotes, with GDPR framework?
Yes, I think I'd be extremely careful of describing myself as GDPR compliant. I think, as I said before, this is a law, and it's quite difficult to guarantee you are complying with a law which is subject to interpretation. I think what I'm really trying to say is if you have a good governance framework, if you have independent reviews, which Gina's alluded to, that you can talk about. You can talk about having independent reviews that perhaps do have a standard against them, which whilst themselves can't guarantee compliance with GDPR, are absolutely demonstrating how seriously you treat the information for which you are custodian. And I think that's really the point, is being able to demonstrate publicly that you have a very high standard in your company to keeping people's data secure.
So Gina and Ian, if there was one piece of advice that you would like to impart to our listeners who have either just begun or are getting ready to begin evaluating their GDPR readiness, what would that be?
Thank you, Sabrina. The one piece of advice I would provide organizations that have just begun or are continuing this process is to really think internally about what you're already doing. I think it's an overwhelming law and standard to some, but it really, when you peel back the layers, it is really about data protection and how you are handling the data of your customers. And it's not something that should be that foreign to your organization. It's thinking about where that data is and what you're doing with it and what's appropriate for your users, and maybe
tying up some policies and procedures to make them just a little more controlled for your environment, ultimately to protect the data of those users.
I think that's a very good point, Gina, and I would add to that, I think it's very important to get appropriate external advice on your journey to GDPR compliance. It is a very complicated topic. Although it's simple in its intent, it's very complicated to understand how that applies to you and how you should respond to the risks you might be facing. And I think even if all you're doing is getting assurance you're doing the right thing, I can't stress enough how important it is to get some external advice along the way.
Well, thank you so much, Ian Singer from PKF Littlejohn in the UK, Gina Condron from Frazier and Deeter. Frazier and Deeter would like to thank you for joining us for our podcast. And if you have any feedback or questions, please reach out to us directly and we are happy to address them. We hope you'll join us for our next session in the Culture of Compliance podcast series.